When you receive a final rejection from the United States Patent and Trademark Office, it feels like the end of the road for your invention. But here's something most people don't realize. A final rejection isn't actually final. Despite its intimidating name, you still have multiple pathways to secure patent protection for your innovation. Understanding why rejections happen is the first step to overcoming them. A patent examiner issues a final rejection when they believe there's a clear patentability issue that hasn't been adequately addressed. This typically occurs on or after the second office action, when amendments made by the applicant fail to resolve the concerns raised in earlier reviews. Patent rejections fall into several categories under United States Code Title 35. Section 101 rejections deal with subject matter eligibility. Your invention might be rejected as an abstract idea, natural phenomenon, or law of nature. This is especially common with software and biotechnology patents. Section 102 rejections concern novelty. If your claimed invention already exists in prior art, it's not considered new. Section 103 addresses obviousness. Even if your invention is technically novel, it might be deemed obvious when combining multiple existing references. Section 112 covers specification and claim issues, including inadequate descriptions, lack of enablement, or unclear claim language. Each type of rejection requires a different strategic response. The most common option after a final rejection is filing a request for continued examination, known as an RCE. This reopens your application and gives the examiner another opportunity to review it based on new amendments you submit. An RCE does come with costs. Large entities pay $1,200 for the first RCE and $1,700 for subsequent ones. Small entities receive a 50% discount, while micro-entities get a 75% reduction. Despite the expense, an RCE provides a fresh chance to address the examiner's concerns. A more cost-effective alternative is the Amendment After Final, or AAF. This option involves no USPTO fees, though the examiner receives limited time to review your submission. An AAF works best when you can make straightforward amendments or arguments to overcome earlier rejections, particularly for minor issues like claim amendments to resolve Section 112 problems. The After Final Consideration Pilot Program, or AFCP, is a newer option that gives examiners more time to consider your AAF. To qualify, you must have received a final rejection, filed an AAF, and made an amendment to at least one independent claim without broadening it. You also need to agree to a telephone interview if the examiner requests one. If your AAF doesn't resolve the outstanding issues, the examiner issues an advisory action. At this point, you face several choices. You can abandon the application entirely, file a new application, submit an RCE to reopen prosecution, or file an appeal. Appeals represent a more formal challenge to the examiner's decision. Before filing an appeal, you must submit a notice of appeal. Your case will then be reviewed by the Patent Trial and Appeal Board, known as PTAB. The appeal process is lengthy, often taking over 2 years, and expensive, with fees starting at $2,800. A pre-appeal brief offers a middle ground. You can file a 5-page brief outlining the key issues along with your notice of appeal, and there's no filing fee. A panel of 3 examiners, including the one assigned to your application, reviews the brief. This process can sometimes resolve issues without a full appeal. Section 101 rejections deserve special attention because they're particularly complex and constantly evolving with new case law. To overcome these rejections, focus on demonstrating practical application. Show how your invention improves a technical field or enhances computer functionality in concrete ways. Use the USPTO's subject matter eligibility guidance to your advantage. The 2019 Patent Eligibility Guidance and its updates provide examples and decisions that can support your arguments. When amending claims, be specific. Include concrete steps that tie any abstract ideas to real-world applications. Avoid overly broad or functional claim language, as this often triggers Section 101 issues. Instead, use precise technical descriptions. If abstract ideas are present in your invention, argue that the implementation itself is inventive and goes beyond routine or conventional approaches. Examiner interviews can be surprisingly valuable throughout this process. These informal discussions provide insight into the examiner's reasoning and expectations. You can clarify ambiguous claim language, understand how the examiner interprets prior art, and test potential amendments before formally submitting them. Interviews are particularly useful for discussing eligibility under Section 101 or obviousness under Section 103. Scheduling an interview soon after receiving a final rejection may save significant time and lead to more favorable outcomes than written responses alone. The difference between final and non-final rejections is important to understand. A non-final rejection starts the prosecution process and invites dialogue. A final rejection typically follows when earlier objections weren't adequately resolved. However, as we've discussed, final rejections can still be challenged through multiple avenues. Many applicants wonder whether it's better to appeal or file an RCE. The answer depends on your specific situation. An RCE allows continued prosecution with the same examiner, giving you another chance to convince them directly. An appeal elevates the matter to the Patent Trial and Appeal Board for an entirely new review by different decision makers. While you're not legally required to work with a patent attorney, professional legal support significantly improves your chances of success. This is especially true for complex rejections under Section 101 or cases involving multiple prior art references. Patent attorneys understand the nuances of patent law and can craft more persuasive arguments. Receiving a patent rejection, even a final one, is not the end of your journey. It's simply a stage in the prosecution process that requires strategic thinking and careful response. Understanding the types of rejections, knowing your procedural options, and choosing the right strategy for your specific situation are key to ultimately securing patent protection. The patent system provides multiple opportunities to refine your claims, address examiner concerns, and demonstrate the patentability of your invention. Whether through an RCE, an amendment after final, an appeal, or examiner interviews, you have tools available to continue pursuing protection for your innovation. The key is understanding which tool to use and when to use it.